We've concluded the special session of the Planning Commission, and we will now begin the regular meeting of the Planning Commission. Begin with roll call.
Chair Spears.
Present.
Vice Chair Hutt.
Here.
Commissioners Catalano.
Here.
Dennison.
Here.
Desai.
Here.
Fryerman Hunt.
Here.
Pevsner.
Next on the agenda is a report from our closed session from the City Attorney.
Thank you, Chair Spears. The Commission met in closed session this evening with legal counsel to receive a briefing on a matter of potential litigation. No action was taken, and that is the end of my report.
Okay, thank you. Next up is approval of the agenda for tonight's meeting.
I will so move.
It's been moved
Second.
and seconded. All those in favor?
Aye.
Anyone opposed? Okay. Next up on the agenda is the approval of the minutes of the regular meeting on June 21st. Anyone want to make additions and or corrections?
I have no corrections.
I have none.
None.
Okay.
Move for
Go ahead.
oh, actually, I wasn't at that meeting.
Okay. Well, then I will move for approval of the minutes of the meeting of June 21st.
Second.
It's been moved and second. All those in favor?
Aye.
Anyone opposed? Okay. And now we come to the point of our audience comments. At this time, any person may address the Planning Commission concerning any item that is not listed on tonight's agenda. The Planning Commission welcomes your participation and input, and when addressing the Planning Commission, please begin by stating your name and address for the record. Please limit your comments to no more than 4 minutes in order to provide a timely meeting. Okay, seeing no one approach for audience comments, we will close the audience comment section and begin with our first item. Looking for a staff report.
We have a design review permit and reasonable accommodation for a property located at 350 Olive Tree Lane. This was a project that was continued from the May 3rd, 2018 Planning Commission meeting. Jonathan Perez is the assistant planner handling the project, and he has a PowerPoint presentation for you this evening.
Good evening, Chair, members of the Planning Commission. The item before you, again, is design review permit 18-02 and reasonable accommodation request 18-01, located at 350 Olive Tree Lane. The code sections that are in our municipal code pursuant to section 17.20.027.c.3, design review permit is required for a lot areas from 11,001 square feet and up to exceed 3,500 square feet of gross floor area, and pursuant to code section 17.61.010, it's policy of the city to provide people with disabilities reasonable accommodations as necessary to ensure equal access to the dwelling and or place of business. The proposed project is a construction of a detached 600 square foot garage in the front yard area. The site plan that the applicant provides, which are also on the dais. I know it's kind of difficult to read on the actual screen, so I've provided actual hard copies on the dais. But the revised site plan does include callouts from the house to the garage, which they list as 9 feet, in addition to the garage, proposed garage to the, street, which is 26. It also includes the driveway width of 18 feet. There was also a entry plan mapping the radius of the cars going into the garage. Oops, there we go. Noted by the dashed lines. In addition, there was a backup plan provided backing out of the garage to go into the street, which again are indicated by the 2 dashed lines. Again, the proposed garage floor plans, which again are 2 12-foot bays, as you can see on the screen. Elevation plans of the proposed project. Some more elevations. The rain barrels have been removed from these drawings. I believe there were rain barrels that were provided in the prior meeting in May. They have eliminated those in the elevations here. Visual simulations of the proposed garage. And then actual photographs. This is from the south, looking at the actual pad space. And then the findings, staff believes that the findings can be made for design review permit 18-02. The explanations have been provided in the actual packet that were posted online, as well as, well, I don't think, yeah, they were provided in the packet that were online, the actual full design review permit findings. As well as the findings for the reasonable accommodation. The alternatives. The Planning Commission can approve the request for design review permit 18-02 and reasonable accommodation 18-01. Approve the request for both entitlements with modifications. Deny the request for both entitlements and state the findings for denial, or continue the project and provide direction for the staff and the applicant. Staff recommends that the Planning Commission approve design review permit 18-02 and reasonable accommodation 18-01, subject to the conditions of approval in the attached resolution. And that concludes the presentation.
Any questions for staff?
Yeah, I have one question that I just came to mind, and you mentioned the rain barrels that have been deleted. And then I also looked at the Public Works conditions, and Public Works condition number 2 is a little cryptic that says review for low impact design requirements. Does that mean that they're going to have to comply with the water saving landscaping or not?
That was the direction the Public Works gave. They will, eventually have to, one way or another, comply with collecting that rainwater. Either way, that will be addressed, or should be addressed when, should this project be approved, and through the plan check process, they will typically go through the Public Works process, and then grading and drainage will be, I guess, fleshed out.
So that could also include a bioswale if they chose to go that direction.
Yeah, I was just wondering, one of the findings that we make is that they have to have sustainable building and landscaping practices, especially water-saving features. Could we just specifically call out that they're going to comply with, I forget the terminology for the water-saving landscape requirements?
Yeah, the lid.
But the lid is broader than just that, right?
It is, and given the fact that this is a design review application, and in the past, this commission has also requested to see how the landscaping is going to look with the design, it's reasonable for the commission to ask for, excuse me, what is the specific LID application that is going to keep the rainwater on site. That's the whole point, is to trap the water on site, which is not what we used to do, but it's what we do today. We can't use rain barrels for it. So what are we using? So it would be helpful if this condition were more specifically stated, and you can ask for that.
Okay.
I mean, in the past, we have asked for actual plans for that, right? Part of the application.
Well, I guess my concern is that I know that under the water saving landscaping plans, there's a certain threshold that you have to get over in order to trigger it. And I want to make sure that we trigger it, because we're doing a specific finding about water saving. I don't want just the standard rules if somehow there would be some way to get under that threshold. I want to make sure it's applied. That's what I'm getting at.
We'll make sure that Public Works gets that message.
Anyone else?
But that could be also listed as one of the planning conditions? Is that listed as a planning condition?
It can be. You could,
Well,
you
it's
can
under
ask.
Public Works conditions, right?
Yeah.
Number 2.
You can ask for it to be called out specifically and shown in the plan so that you can understand exactly what low-impact development strategy is being used, because there are various ones. Some of them are more visible than others, and it's not clear on the plans which one is going to be chosen, and that might impact your design review decision.
I believe it does say that the paving is going to be permeable.
Right.
Concrete, okay. So therefore, that would be that would be one serious feature that they would have provided along these lines. So actually, all that paving is a very large area of paving wouldn't count as part of what you have to abate under the LID requirements.
Right. It's just that, you know, when we saw it before, we had rain barrels, so we understood that's how the water was being captured from the roof surfaces. And now we're finding out that rain barrels aren't sufficient and they've been deleted, so I'm just worrying. So what are we gonna do?
Well, you know, so that takes, if you want to believe that the pervious or permeable concrete really works, which it does just to a point, then you still have a lot of roof area that needs to be discussed.
Right.
Okay, you can't just ignore that because they use the right paving material.
Jonathan? Yep. In the new drawings, have any of the dimensions changed? Has this structure moved in any direction or changed size between this iteration and the last time when we saw it?
No, mainly it was just a few call-outs, and then the turning radius, the dimensions did remain the same from the prior.
So the other thing Jonathan, we had some questions and asked for a architectural plan. Is the SE development, do they have an architectural license?
I do not believe so, no.
What?
I don't believe so, no.
Okay. So, okay. Yeah, those were two of the elements that we talked about last time, our requests.
One other just clarification. On the drawings, it states minimum setback is 25 feet. That's incorrect, right? It's a prevailing.
Correct, it is prevailing setback, that's right.
And what is that value?
30 feet 6.
So that 25-foot number doesn't really
No.
apply.
Are there any other questions for staff?
These are all the plans we have, so we don't have any details about materials or the windows or any of those usual things we have on plans that we get.
Yeah, correct, those are the revised.
This is the, okay, this is extended, okay. Thank you.
Any other questions for staff? All good? Okay. At this point, the applicant would like to make a statement?
Thank you. I have a PowerPoint deck that I gave to Jonathan, so he's going to load that up for me. Sorry. And while he's doing that, maybe I can quickly address the landscaping features. So in the application, there's 3 mitigating strategies. The first is we're going to use low water, drought tolerant plants. The second is, and maybe when we look at a picture up here, we can show the dimensions. We wanted rain barrels. We were told we couldn't have them, so we removed them. But subject to the city approving, we can reverse the slope of the collection system and put the rain barrels, tuck them in behind the garage, I think, so that they wouldn't be visible from the street. but they would still be there to correct the rainwater. And third, and I'm not sure if it's in my slide deck, but we can stop if we see it, there is a front swale and a back swale, so we will definitely work to direct the water into the front swale and to direct it into the back swale, and if we need to make some adjustments on the size and capacity of the front and or back swales, we can definitely do that. But we subscribe to the city's plan for rainwater collection and drought tolerant planting, so that's definitely something.
Yeah, I think the issue
plan
with
to
the
do.
rain barrels is insufficient size. It's not a,
Yeah.
it's not a design issue, so
Mm.
it's, you have to have a cistern, which apparently is a bigger rain barrel.
But
Oh,
we don't
okay.
have any information about those swales, those landscaping.
They're in the application, they're not on the drawings. The swale was not part of the application, I was just pointing out that they do exist, and we can definitely elaborate on those. But, so first, thank you all for an opportunity to come back and meet with you. As Jonathan very clearly identified, we have two issues in front of the commission today. One is a request for a reasonable accommodation, and the second is a design review. I think Jonathan covered most of these points, but we are requesting to construct a two-car garage in the front of our residence, which is located on a private lane. And our application is supported by a request for a reasonable accommodation. And I just wanted to highlight that since some of the commission members have changed since the last meeting on May 3, that we did bring forward over 200 signatures in support of the project, as well as a number of letters that I think are in the record. And then there was also a number of people who actually came to speak last time. We didn't try to rally the same troops again this time. But there is broad community support, we believe, for this project. A quick recap from the May 3 commission meeting. So the two issues were reasonable accommodations requested, and there was a little bit of confusion, I think, leading into the hearing. So the focus point of the discussion was where the garage was going to be located on the property. And there was a miscommunication between us and the city. There was actually three other elements that were part of the request. One was positioning of the garage vis-a-vis the house. The second was door dimensions, and the third was the internal space within the structure itself. We also collected some feedback from the commission, where the commission asked us to add some missing dimensions to the drawings, correct the images to depict a garage door height vis-a-vis a roof line that looked misleading, and incorporate the turning radiuses on the driveways, which Jonathan covered in his comments. So if I can turn to the request for accommodations. So at the last meeting, the commission invited us to do one of two things. One was to consult with an architect, as Chairman Spears identified, to modify the building to avoid the encroachment that we were proposing to encroach into. The second was to provide further information in support of our requests. So we pursued option 2, just to be clear. So we went back to the city, clarified what our 4 requests were in my last slide. We provided documentation in support of those requests, and we got confirmation with the city that the documentation we provided was sufficient to support those requests as we understand it. So our understanding coming into today is that we have met our burden for demonstrating the need for the requested accommodations, and the issue becomes now whether that request is reasonable. And I'll let your attorney advise you on that because I'm not an ADA attorney. In terms of the design review, so we collected, with the help from Jonathan and Vincent, the list of the requested changes the commission was looking for to make sure we got those accurate. We provided revised documents in advance for review by the staff. And to our understanding, all of the requested changes from the commission have been made in the revised drawings. A couple of things I wanted to highlight, which might be helpful because I already heard one question come up. So the house, some of the design highlights, the house will be, the garage will be consistent with the overall design of the house, which is a Tudor style. We had remodeled the house in 2015. 2015 and 16, it was a long project. But our intention is to use the same materials, windows, exterior finishes. You know, we did some architectural detailing and the same colors as the existing structure. We also took some effort to reduce the mass and scale of the structure, and I called it out this time because my explanation last time I think was pretty poor. But you can see the existing structure in the lower left-hand corner, sorry, lower right-hand corner, and it has a shed roof on the that's actually a bedroom. So we mimicked that same styling and put a shed roof to the north and south side of the garage because the dimensions are a little larger. But the dimension of that inner structure actually matches the same feature that's on the south side where the cars are kind of parked in front of in that image. So we attempted to mimic styling that was already in the house, roof lines that were already in the house, and the features that were already incorporated into the house, while at the same time reducing the mass and scale of the structure. We positioned the garage with a slight offset, it's hard to tell in this image, to enhance a little cottage-like feel and avoid just a long straight line along the north side. And we located the garage approximately 26 feet from the inner easement, which is into the prevailing setback, but is greater than the minimum setback in the city of 25 feet. Some questions we talked about last time, the character of the neighborhood. So I thought it would help if anyone has not, I know several of you came up to check out the lane, and for anyone who didn't, this is a private lane, there's no through traffic. 5 of the 10 houses that use Olive Tree Lane to access parking have parking structures immediately facing the lane and have parking structures located inside the 25-foot standard setback. The 6th home of those 10 has a 6-foot block wall located immediately on the easement for the length of their property, or almost the entire length of their property. And again, our proposal is to come at 26 feet, which puts us roughly in the middle of where the neighborhood is today. So I also wanted to, for anyone who hasn't been up there, take you on a tour of Olive Tree Lane, if you'll indulge me. So the first house on Olive Tree Lane is actually a Grandview address. So you can see the house, it's on the right-hand side. If you're looking at the image on the left, and I stood at the easement and took a picture of the house, which is, so I'm standing west, taking a picture to the east, and that house is about 1.5 feet from the setback, or from the inner easement. On the west side here is the next house. It's 201 Grandview Avenue, and the parking structure there has about a 6-foot setback. The next house up on the left-hand side is 301 Toyon Way. The parking structure there is about 12 feet from the setback, or I guess on that side it's from the outside easement of the lane. The next one is 330 Olive Tree Lane. It has technically a 68-foot setback to the house, but you can see it's got a 6-foot plus concrete block wall that's immediately on the easement itself. The next is 340 Olive Tree, which has a 52-foot setback. The garage is frontward facing, but it's pretty far back there and blocked by the cars. 1350 is the next, or 350 is the next house, so that's ours, obviously. The next one up is 360 Olive Tree Lane. It has a 45-foot setback. 370 Olive Tree Lane has a 13-foot setback. 380 Olive Tree Lane has a 12-foot setback. And 390 Olive Tree Lane, it's the end of the lane and goes up quite a bit of distance up to the main structure. So hopefully you enjoyed that trip down Olive Tree Lane. Just to recap our project, the design is consistent with the Tudor styling of the home, made of the same materials, finishes, and colors. In our opinion, it is thoughtfully designed, and we did make efforts to reduce the mass and scale of the structure. We believe it is consistent with the character of our neighborhood. We do have a lot of community support for this project, and it is supported by a documented request for a reasonable accommodation. And that was my last slide, so I thank you for the opportunity to come back to you, and if you have any questions, I'm happy to try and answer them.
I just want to comment real quickly. I think that the first properties shown on the tour there, with the side of the house, yeah, and the garage is very, very close, aren't we talking about side yard setbacks in those cases as opposed to front yard setbacks? So wouldn't they have just been under different regs anyway?
It is part of the calculation that went into the prevailing setback.
Shouldn't have.
That one was
And,
thrown out.
and whether, I mean,
It wasn't included. This one was thrown out.
Because it's on Grandview.
Yeah, so it's not a front yard setback.
It's a side yard.
but whether it's a set, I mean, I agree, I understand your point, but it does, because one of the findings on the reasonableness of the reasonable accommodation is the impact on the character of the neighborhood, and I do feel, even though it may not be calculated for purposes of a setback, it is pretty influential on the character of Olive Tree Lane, given that that's your entry point into the lane.
Is the table calculating that in our packet?
Yes, it does. Correct, Jonathan? The prevailing setback was calculated in the packet, correct? Yeah.
It was in the previous packet.
Yeah.
Oh, yeah.
But I think when we calculated that, even if this was included, it would have been thrown out.
The
'Cause
smallest.
it's the smallest and the largest.
It's the smallest.
Right. Well, it's just, I think that if, there's one house that has a large block wall right on the property line.
But that's not the setback. Yeah.
Well, I understand, but it's also one of the biggest if not the biggest at 65.
Oh.
So I guess there's an issue of how you calculate the math, which you do based on the code, and then there's sort of the look and feel.
Yeah.
And so I think the idea is that presents a very different look and feel than the math tells you.
Mm.
We're not arguing that we're not asking for an encroachment. We're just saying that when you get to the reasonableness of the accommodation we're asking for, you have to look at the character and impact, or the impact on the character of the neighborhood. And so our position to you is that a block wall, which may not be factored in as part of a setback, still very much influences the character of the neighborhood.
Well, I think there are two, we have to look at both of those issues. Let's not prematurely wash the two of them together here.
So at the last time we met, we made a number of suggestions so that we could come with some reasonable accommodation, and we could work with you and have some sense of progress. I'm sure were aware that we were concerned about the distance that this structure would be from the front.
Correct.
And we offered we offered a number of proposals that would accommodate that setback and still allow an opening in the garage. But one of the things we suggested was an architect, not a designer.
Right.
Because an architect can also offer other kinds of designs. There are many, many ways of housing a car in this location. And since there is already a garage on this property, we were looking at this structure in the front of the house as being the reasonable accommodation.
So I guess that was the point, and sorry if I can jump in.
So having an architect assist you in its design would allow you to have the structure to complete this project and do so in a way that is informed. The other thing that we had questions about, that we asked you about, is we did not understand, while we don't need to know the nature of what's causing this, we do need to understand a few things. We were very specific as to why it needs 2 doors of that size, since the accommodation is for one person driving one car. And I felt that we were going to get some specific direction on that. We also put in requests that, like, if you have, how are you going to get into this? How do you line up? These new drawings by some designer has some dotted lines on it, but it doesn't answer the question as to what is it about two 12-foot doors that addresses the issue. And so I am still unsure of why we cannot get to a win-win here where we have a structure in the front of your house that meets the reasonable accommodation, but is also in compliance with the setback. So that the car can be parked inside of whatever area, and that the city's zoning regulations can be followed. And so I need your help on this as to what is it about two 12-foot doors that is essential for this?
Sure.
What is it about the placement of this building in relationship to the existing house that accommodates your need? Because the building can move. The building is not built yet. It can be. There is also the fact that there is a space in between those two 12-foot doors. There's a space on either side of those two 12-foot doors that could be reduced. So in our give and take with this commission, we often look for good faith effort on the part of the applicant to at least acknowledge the concerns of the commission and make some kind of accommodation or changes that at least says that the applicant has heard what the commission is concerned about and can come back and say, this is what I've heard you, and this is how we are going to address, we want to address those concerns. The reason I asked Jonathan what has changed on this was because I wanted to hear what is different. And I'm told now nothing has changed. So you're going to have to help me understand why we are not in the same place we were the last time you were in front of us.
Sure, and happy to address that. So first, and I've put this slide back up, when we appeared last time, I think there was a fundamental lack of understanding as to what was being requested. So we had put forth a request for 4 elements. The commission considered the one, which was the location of the garage, moving it from the back to the front, and there was a lack of communication to clarify that there was 3 other elements within our request that had to do with the positioning of the garage vis-a-vis the house, and we can put the Jonathan slide back on to show the vehicle patterns. Actually, I think are informative because it shows where the cars have to back up in relation to the physical structure of the house to safely navigate that without hitting it. It also, the door dimensions, so I'll let your attorney advise you. The reasonable accommodation request is that you should have equal access and equal use of your home. So if you have 2 cars and you need to park 2 cars at your house, you have to have two garages to have equal.
So you're telling me there are 2 people that need reasonable accommodations in?
No, there's 1 person, but we have 2 cars.
And
you're saying that
but the person can only drive one car at a time.
Yeah, the finding here, excuse me, the finding here says specifically that, that it's the accommodation for the person who is in need.
Yeah.
But so now
The
you're
person-
saying that person can only drive one of the 2 cars in their family.
Well, they're not parking you're not.
Simultaneously.
We frequently move, we have 2 cars, right?
Yep.
And we each drive one at a time.
Yes,
I presume you each drive 1 car at a time.
that's correct. But if the car's located in a stall that you can't get in and out of, then either someone has to move the cars for you or you're stuck.
I have a driveway that's 12 feet wide. And my wife and I park in that driveway. And some days I have to get up and move my car so she can get out, and some days she has to get up and move her car to get I'm out.
Well, in this situation, what if there's no one else home and you're the only one home and you need to get in and out of your garage? I mean,
But there is one vehicle parked in the accommodated bay, correct?
Yeah.
correct.
So you're saying if you wanted to use the
So I'm
other
saying if
vehicle?
someone took that car and the person needed access to the car that was in the second bay, and if the second bay was less than 12 feet, you wouldn't be able to get.
But that sounds like a family accommodation. That
Yeah.
sounds like a member of the family has to be responsible for accommodating somebody, not the planning commission. In other words, if there's no communication in the family, or the family is not supporting the person that needs the accommodation, that would be a problem. But I'm assuming that your family is ready to support whoever needs the accommodation.
That is absolutely true, but I would
Okay, well,
also.
then it's not a
encourage you-
problem.
Well, but I would encourage you to talk to your attorney, because I don't think that's what the law requires.
Oh, boy, here we go.
Would
I'm-
you
I'm
like
not trying to be difficult,
Would the
I'm
council
trying to
like
state
to
a fact.
comment
No,
on
you're
that or
not.
not?
Can I chime in here also, just from a practical standpoint? We have different people driving the two cars at different times. And so if one vehicle is taken, and this happens often,
So
In our household.
can you come to the microphone to make it, this is, because this,
yes.
We need to get it.
If one person takes one of the vehicles, then the other vehicle remains, and I'll take that one. And we alternate very frequently. So if one were in a smaller bay and I needed that one and I couldn't access it because of the reasonable accommodation condition, then I'm stuck without a vehicle, even if it's there. So if I have to, have a neighbor or somebody else, I mean, that's not what, a normal person would have to do in the same circumstance. So, even though obviously I can't drive two vehicles at the same time, but we drive different cars at different times, and it happens all the time in our household. So I hope that is understandable to you. If I am the only one at home and I can't move the vehicle that's in the accommodated bay, then.
well, that would imply that somebody left you in that position.
Well, I mean, I don't know how to respond to that. It just, life circumstances are such, sometimes, hey, there isn't enough gas in this one, so I'll have to refill that one. And that's something that happens frequently, is I will fill the tank up and take the car that has the thing. So
But I would assume that if I had a family member that needed a reasonable accommodation, I would be cognizant of that and sensitive to that and responsible to that, and make sure that I did not leave my fellow family member who was, in a position where they were in a tough position. I mean,
but life takes over a lot of times.
so what we're looking at is that we have no problem granting a reasonable accommodation. I guess what we don't understand is why it needs to have the dimensions it has. And we would like more information so that we can make this decision, because we have to, findings. Have you read what the findings are that we have to make? Because we are responsible for these findings. This is part of what the rules are. And so in order to make these findings, we have to act on and vote on information that we've requested. And so what we're struggling with is, can we please get that information? And the information that we're going to need is, one of the pieces of information is, door dimensions, position of the house. How do those facts address the accommodation?
So it's a fair question. It is in the material, the documentation that we submitted. And if we want to get into a debate on that, I would actually ask that we go into private session, because it contains.
I would like to ask a question. I would like to ask a question about, would it be possible to move the house back close, move the garage 2 feet closer to the house?
It's possible, but that makes it difficult to it's hard to get into without going into personal medical information, which is why
I don't want any
suggesting-
personal and medical information. I just want to
So-
know, is there a reason
then-
why the garage could not be, is there a reason that applies to this accommodation that has to do with why the garage could not be closer to the house?
So the the separation between the garage and the house has to do with the disability and the accommodation.
It has to do with being able to back out the car? Is that what it has to do with?
Navigate, correct.
Yeah, well,
Is there a
look,
reason why this couldn't be one 20-foot garage door rather than two 12-foot garage doors? Or one 24-foot garage door rather than two 12-foot garage doors?
When we have two stalls, it keeps the dimensions identical, rather than things shifting between different vehicles by different people driving it. So it's always the same when they're separate, and it's easier for me then to judge to the best of my ability when it's always, you know, if the only issue is the one vehicle within any given bay, so that I'm not juggling multiple variables, if that answers your question.
Would it be possible to shave off 6 inches from between the cars and 6 inches from either side of the garage? And make it a little bit smaller so it doesn't encroach as far? Could you take one?
6 inches
say-
wouldn't avoid the encroachment.
Well, let's say you moved it 1 foot closer and you took out 6 inches 3 times, that would take away 2.5 feet of the encroachment.
I have real reservations about any movement closer, because I know how it feels in that space. And this is the minimum, particularly nighttime issues raise much bigger issues. So
You could tell the difference between 11.5 feet and 12 feet.
I can't tell you, I can't go into the things without going into particulars, but for my condition, every inch counts.
What,
So we
what's,
consulted a medical professional who gave us the opinion, so it's not us making up an opinion or.
Right.
you know,
Well, it's
he-
also how I,
it's her-
they gave you the opinion that 12 foot's the magic number for the width?
that would be what she needs to navigate safely, the 12
at a
foot,
minimum,
and that she needs a certain amount of interior space within the structure itself to safely navigate a vehicle. And I really feel like we're getting pretty close to the personal medical information and history, so I.
Well, no, we don't
We're
want any medical
actually
information.
not.
We're
I'm
just
gonna
talking
butt in
about
here.
the
I'm
structure.
gonna butt in here.
Yeah.
What we don't need is the diagnosis. That's never coming into the record, and that is not something that's known by the
We're not
commission.
interested in it.
And the commission doesn't want to know it. But what is necessary is to understand what is the exact accommodation. And we're not saying we want a garage of this particular style and design and size. That's not what this is. The issue here is the difficulty of the applicant to navigate a vehicle between a space that's more narrow than, say, 12 feet, or whatever the magic number is. That's the issue. And we can talk about that. That doesn't violate anybody's privacy rights. But what we don't want to know about is the diagnosis. In order to understand and offer a reasonable accommodation, and there can be more than one way to get there, we have to understand what we're shooting for. And what we do understand, and they can correct it if they want to, is the difficulty to navigate a vehicle in a space more narrow than whatever that magic number is, 12 feet. And part of the reason I think that this commission is having difficulty with that is that 12 feet far, far exceeds any parking space or any legal lane on a road.
Can you add to that, city
I
attorney?
don't think it does, the legal lane, the dimensions of a legal lane are 12 feet. And that's with no structure on either side of you.
Actually, there are quite a few lanes that are less than that, that are 11 feet.
The California design guidelines,
Well, it's the design guidelines, but if you go on a lot of freeways in California, they've been shaved to 11 feet to allow for extra room.
And in Sierra Madre, Grandview just got repaved and they put a line down the center so you don't have that 12 feet anymore that you used to take out of the center.
No,
So-
but when people drive, we often go in over the divider in order to avoid traffic, vehicles parked on the side. So that's, as a practical
Yeah,
matter.
that's the problem with Grandview right now. It's not 12 feet.
Yeah, but what I'm saying is a practical matter, the lines may be drawn wherever they're drawn, but vehicles drive over that divider all the time, and I know I'm one of them, so.
So the
safe.
applicant suggested that we ask our city attorney that the actual reasonable accommodation, is it that we accommodate 2 of these oversized bays? Or what constitutes us reasonably accommodating the need?
Well, reasonable minds can differ on that, but the point is that it's not just one thing. A reasonable accommodation, you're not required to grant the exact accommodation that's requested if another accommodation could also suffice. That's the issue of what's reasonable. So if you're asking me whether a 12-foot bay would be sufficient, given the turning radius needed for the individual needing that, the answer would be yes. That's one accommodation. It's not the only one. There could be several other potentials, but yes, that would be one way to resolve it. That would not involve an encroachment into the front yard setback, which would normally require a variance.
So is there anything that states we would be violating or not allowing equal use of 2 vehicles? Like we would be violating that equal use
It's equal opportunity to use and
for
enjoyment.
either vehicle?
No, not at all. I mean, some people don't only have a single car garage. Some people have no garage on their property. There's no inherent right to have a 2-car garage. The issue here is really design review. The reason the size of the structure triggers design review. And that would normally give this commission, in terms of design review, the preference to place the garage at the back of the property. There is a sufficient width on one side of the property to drive all the way back to a garage at the back, which would then be less of a scale and mass issue. However, because the applicant, and we're not arguing over the 12 feet, we take 12 feet. I mean, that's what they say they need. The applicant it would have a difficult time that someone without those needs would not have to be able to drive all the way back. So the reasonable accommodation, first and foremost, is to allow this garage in the front yard as opposed to the back, because normally you would have the discretion within design review to say located in the back. Now beyond that, we do need to look at a not so much sizing, but the way that the garage is placed in the front, and the widths of the 1 or 2 bays, as you will, and consistent with whatever other zoning laws that apply here, one of which is the front yard setback, to find a way to approve a garage in the front yard, which might not normally be the preference under design review. And the applicant has proposed a very specific way of the accommodation, and that's fine. That is one potential reasonable accommodation, but it's not the only one.
I'd just like to address this issue of moving cars around. We do it all the time in my house, where someone's car is parked in front of someone else's car, and that person moves it so that they can get to the other car that they're trying to get to. It's not an unusual activity. Bob just said his family does it. This is not an unusual activity to have to jockey cars around. I think it's a common thing to do.
I was an assistant principal for the Los Angeles Unified School District. We made reasonable accommodations for students with learning disabilities all the time. One of the dimensions that had to be documented in the districts was what was the family going to do to support the person that needed the reasonable accommodation. The district had a responsibility, and the family had a responsibility. I believe this commission is is willing to move forward and provide a reasonable accommodation by placing the garage in the front. What I'm not hearing is, what is the family willing to do to support that person that needs the reasonable accommodation? I'm not sure it should all rest on the commission to resolve this issue. And we're happy to do that. So, we don't want to be painted as the person that, oh, we have no sympathy for this. The problem is that we have asked many times about where can we meet on this, and we have not heard from the applicant that there is any movement. And we've heard a lot of statements from the applicant that seem to imply that the family is not willing to assist the applicant, the person that needs the reasonable accommodation. And so you can try to push that back on the commission, but as one of the commissioners, I'm kind of reticent to take that responsibility that I need to solve a family matter. I'm happy to help an accommodation, and I would like to see this resolved tonight, actually. But I'm not hearing from the applicant that there is a way forward, or that you have at least heard what the commission has for its concerns. I mean, you don't understand what our concerns are?
So I guess a couple points. One, I don't think it's fair that the family will not try to help my wife out to address the situation.
But we've heard from your wife that she can't rely on the family to have a car in the right place.
Well, I think she said it happens occasionally from time to time. And yes, if this, isn't something that can be done, then, maybe we'll have to figure out an alternative strategy. But I just wanted to address that point, that I don't think we're telling you that the family's not willing to pitch in and do something here. I think to your point on did we hear the commission? So two things on that. One, I thought we heard the commission tell us last time to go back and either address it architecturally or bring further information. So we did bring the further information. It was part of the original request we made. We did scale it as, and try to position it as tight as we could so that we limited the amount of the encroachment we are seeking. So we didn't bring you a half-baked idea, in our opinion. We brought you an idea that we put a lot of time and energy into, and we talked to the city planning department for months and months about what the commission's, input was likely to be, and we tried to address that all up front so that when you saw it, it was a fully or mostly fully baked idea instead of a, half-baked proposal. So I think we did anticipate the commission's need, desires. We did try to build that into the design. We knew what the dimensions were and the requirements were going in, so we tried to size the building exactly to meet those requirements. And our challenge is
But working around my limitations, so
Right.
that you understand that it wasn't, some piecemeal, or.
I guess the process is we understood the limitations, and then we went into a design that was going to meet those limitations. That was our plan.
I wasn't here at the last meeting, obviously. One of the things that's been difficult for me to get my mind around here is there are actually three issues going on here. One is the reasonable accommodation. The second one is the design review, because this building is over a certain number of adds so many square feet to your house that it has to meet certain requirements in terms of design review to add that many square feet on top of the house. And the third one is, normally if you build into the front yard setback, that would require a variance. So it has nothing to do with design review. And so you're asking to, instead of having a variance for this setback, we're being asked to handle that through this reasonable accommodation thing. So that it kind of is not the way we would usually handle a setback issue. Because the setback that's required, there's two design issues here. One is the square footage of the house, and if you're going to of this garage, and if you're going to have that many square feet, it has to meet certain requirements. The second one is the setback. The setback is supposed to be 30 feet 6 inches. It's not 25 feet. 25 feet does not apply on your street. It has nothing to do with this street. The setback from the street that's required is 30 feet 6 inches. so that we have to deal with both of those issues that you're asking, that we're being asked to look at here today, right?
Well, so design review, yes. Reasonable accommodation is.
The reasonable accommodation is putting the garage in the front
Right.
rather than the back.
No, it's all three of those elements, all four of those elements that are on the board. And so it is a request to go into the encroachment for the reasonable accommodation.
2 and 3 were discussed at the May 3rd meeting. I remember that very distinctly. Okay, you're showing this as though they were not talked about at all, but 2 and 3 very definitely were discussed.
You're absolutely right, they were discussed. I think it was not clear that they were part of a reasonable accommodation request.
Can we get clarification? Because we're hearing that the reasonable accommodation is locating a structure that would normally be at the rear in the front.
The reasonable accommodation is to be taken into consideration when you go through your design review analysis. So where you might normally, on a lot of this size, in order to conserve mass and scale issues, require the garage to be at the back, and there is sufficient driveway space for someone who did not need 12 feet of width in order to navigate all the way back and place the garage at the back. So the reasonable accommodation is to be considered when you are applying the design review and the findings for design review. As far as encroaching, that would normally and should require a variance. That's what everybody has to apply for. And I don't want to penalize the applicant now if they weren't asked to provide a variance application. If a variance application had been provided, the reasonable accommodation would have also been taken into consideration if the only way to provide the access and the turning radius to have 12 feet in width in order to locate a car in the garage would require encroaching into the variance. Encroaching into the setback area. Which would normally require variance, then you would also have applied the reasonable accommodation analysis to that in order to make the findings for the variance if you could not otherwise make them. That's a really long answer to your question, but I think that in terms of the findings to grant the design review, which is the discretionary review in front of you, you are going to have to be able to layer in the reasonable accommodation that would support those findings, because otherwise, but for that reasonable accommodation request, you might come to different conclusions on the findings, and I think that's important for the record.
I would like to interject a couple of things here. We were talking before about the idea of the family responsibility and the issue of the interchangeability and so forth. If you had one, just a thought that occurred to me, if you reduced, you took so much width off of that building by having one very, very wide garage door, and in terms of people's sloppiness about how they park in there, if there were a stripe painted up the dead center of the garage, I certainly could get my family to comply with that. You know, respect where mom's got to park. Don't park over the line. You could ask the family to do that, and I think we'd knock a couple of feet off right there. And then also, you know, when I look at this drawing, over here with the backup plan, it's like, look at the kink in there. That's worth a couple of feet, and the backup goes all the way over to beyond the house anyway. So I don't know why we couldn't tweak these things a little bit, and probably between a little tweaking of this layout and taking a couple of feet out of there by having one big door with a stripe painted on there. You know, I think we start to inch closer to what the setback should actually be. I think that there's some bad assumptions built into the basic design of this thing that nobody wants to budge on here. And we ought to be able to budge on them.
So
They're not a big deal.
do you want to bring it back and have us deliberate for a little while? So why don't,
Yeah, I just wanted to point out in terms of backup, it's not a smooth thing because the way that I have to do it is not how someone else would, I guess, a standard way of doing it. I know what I do when I have to back up in particular and the difficulties associated with that. So really, every inch is precious when I navigate, particularly backing out and coming, and it's tight over there. Everything is tight up there, and then going back out. So that's where the accommodation. I don't know how to express this generically. I'm just doing my best. That it's not how you perceive things. I perceive them very differently, and for that reason, those larger gaps and spaces are essential.
okay, well, why don't we bring this back so we can deliberate? So thank you very much.
Thank you.
Okay. Who wants to go first?
I'm sorry, one final thing. We did consult an architect early on in this process, and we discussed the various aspects of this. So we did have some, development ideas for the concept, and that was part of our thought process. And then he ultimately guided us saying, you don't need an architect to draw this because it's very straightforward. Basically, it's a box. But in terms of design and everything else, we did consult one.
Was that an architect that has spoken in front of the Planning Commission and is aware of Sierra Madre's rules?
Actually, yes. Yes.
Did they help you with the layout and the positioning of the doors and,
It was a couple of years ago now, but
or just the look and feel of it?
These findings are the findings that we have to make are not a couple years old.
No,
So and that's part of the thing that's driving our concern right now is that we have findings to make.
right.
And one of the reasons why in the past we suggested an architect is because they are sensitive to these issues and they can help make the project meet the findings. So we're going to come back now and we're going to deliberate, okay?
Okay.
Thank you.
If you're just talking about the construction of a garage, it's very easy to say, well, you don't need an architect to do the construction drawings for the garage. Any credible contractor can do that, but it's the layout, it's the problem solving and so forth that is where you use the architect, and you get those problems solved, then yeah, the contractor can detail it. Really talking about two different things here.
Well, for me personally, one of the things that an architect can do is once they understand the needs of the client, can offer multiple kinds of solutions. And right now, we've only been given one solution, and it hasn't changed.
I think we're dealing with a number of issues here. One of them is that this is an addition. It's not a new house. And I think if we were doing a new house, the architect, rather than, a design build guy, could probably offer a lot of insight. But if you look at this lot, the way the house is already built, the garage goes one place to accommodate the disability that we're talking about. And so part of the issue is we have a disability that we have to accommodate, and it's difficult for us to talk about because we can't talk about certain things and we don't want to talk about certain things. But another part, and I think we need to acknowledge this, is that there's already a house on the lot, and there's a pad for where the garage goes. I mean, y'all should have put the garage in when you redid the house, and it would have been a lot simpler. So that's another complicating factor, and I think that we need to be mindful of that, because I think if we started from scratch, we probably would have ended up with a very different overall design than the ones here. But people don't tear down their houses to, and I don't know if the applicant's condition came on later or what, and I don't want to know. But there's all sorts of reasons why we might have got to where we are now, but we are where we are now. And so we're struggling to accommodate this disability. We have to be reasonable in doing so, but we don't have to just rubber stamp whatever the applicant says. There's two sort of issues from the planning side. One is a prevailing setback. The other are the design review findings. I think that the prevailing setback issue is one where it's sort of a strange and unique situation, because we don't have the standard prevailing setback situation where you go down this sort of street with big houses way far back with big elegant front yards, and then some yahoo wants to stick, you know, a house up front, and every one of the neighbors is like, what are you doing? This is a weird little lane that has houses in and out all over the place, and I know you calculate the prevailing setback to the primary structure, not the wall, but if you did calculate it to that 6-foot wall, there would be no prevailing setback, and we'd go to the generic 25. And to me, when I walked up and I looked, that looked more appropriate to me than requiring that. So I think if you try to get to the spirit of that, and as we accommodate this, that's not a big holdup to me as the other issue, which is the design review. And as I said at the last meeting, if there weren't a reasonable accommodation that had to be made, I wouldn't approve this. It has a garage in the back already. That's good enough, right? Mm-hmm. We shouldn't be building garages in the front, but we have to make this accommodation. They can't drive to the back. It has to go in the front. So to me, if you've already bit the bullet and said, okay, you got to put this thing in the front, and you already have a Tudor-style house, you're not going to put, you know, craftsman-style garage, then if it's an extra 2 feet wide, it doesn't give me heartburn. And so to me, I can't make the findings for the design review the way it's written. I think the design review findings have to incorporate the concept of
reasonable accommodation.
The reasonable accommodation, especially finding 3, finding 4, finding 8, A, D, and F, and we can go over all those in detail if we get to that point. But if those findings could be modified to incorporate that concept, then I could approve this project as it is. And I think that we're really reaching the land of diminishing returns, of trying to shrink the garage down a foot or two or whatever, once we've already stuck it in the front.
Yeah, well,
because it shouldn't be in the front in a perfect world, but like I said, there's all sorts of issues with this that isn't just starting from scratch in a normal place. So
I just want to say that I totally agree with you that I can't make these findings as they're written at all. And I think that they really would need to be rewritten in a way that every single one acknowledges that the only way it reaches the finding is by applying the reasonable accommodation to them. And I think that makes way more sense because, yeah.
I'm going to try to keep it short. I can't make the third finding in relation to siding of the garage in the front. To some degree, I agree and disagree with John. I think, you know, there's a reason we have zoning regulation and ordinances setting prevailing setback. It's not about this house, but it's about the eventual entire block. And there's a reason we implement that zoning strategy in our R1 neighborhoods. I'm finding it very hard. There are many ways to skin the cat on this, and because of that fact, this could be located a foot closer to the house and be 8 feet away, and I think your turning radiuses would be fine still. I think to reasonably accommodate the need, there's nothing, unless I'm wrong, that says we have to provide 2 oversized bays for this garage. One oversized bay would clearly accommodate the need. And then as far as the circus with the cars, I think that's a personal issue. I don't think that's an equality or use of both vehicles. I don't think there's any legal basis for that. I think that's a personal thing. So, given those 2 things, I could not support this project. If this is what we're going to approve today, I would deny.
I'd just be repeating most of what he said. I definitely cannot find for number 3. There's also another a couple of things that I can't really go along with as far as the way findings are written here. One of them, one of the other ones, is high quality architectural details and building materials compatible with the overall project design. We haven't gotten just to add on to what's already been said, we haven't gotten a thing here. If you look at these little graphical things here, this is all extremely substandard in comparison to what we normally look for, what we normally pass on in the way of architectural drawings and so forth. And I don't want this to just get swept under the rug here. If we are going to allow the non-variance variance, we're going to allow this thing to encroach on the front, then I think that we ought to really step up to the plate about the architectural details and massing and so on and so forth that are stated in here as findings to make. And you know, what I'm looking at in the drawings here, there's absolutely nothing that's happened in the way of the comments that I made at the May 3rd meeting that would have honed in any better on the overall design. So even if we wanted to say, well, okay, we're going to allow the whole thing, I'm still getting a pig in a poke here, as I would for any other project anyway. So I deny based on all of that. Can either deny or just ask them to come back with real architectural work here.
I'm torn, but when we look at those first couple of slides of the houses, that's exactly why we have setbacks. Like, that's actually the case for why it is, because we can't go back and change those now that they're there, right? No. So the reason that you do have setbacks is so that you don't end up looking just like that. So that I have a really hard time getting past the setback issue without any alternatives. That's a challenge for me.
Yeah.
So, last time we were here, we made some requests of the applicant, and I, for one, was very hopeful that the commission could get clarity so it could make a decision. The reasonable accommodation to put a garage in front of the house is not a problem, but that can be done easily. We're happy to do that. The problem is the findings we have to make that influence the design and size of what this structure is. When we ask the applicant for information, or we ask the applicant to perhaps consult an architect, provide us with some kind of information, the applicant doesn't seem to be as forthcoming or as cooperative. And I find that to be disconcerting. It appears that the only unique solution to this dilemma is the one that we've been given, so we have no, there is nothing else for the commission to do. And the Planning Commission is used to working with an applicant to resolve and come to some kind of mutually agreeable position. And if you go back to what the Planning Commission has done in the 10 years I've been involved, that's been the process, even to the point where in the past we've helped design a project for people, So we are faced with the fact that the applicant wants a parking structure in front of a garage in front of the building, and okay, that's a reasonable accommodation. We can do that. The question that we haven't understood and that we can't get enough information for is why it needs to essentially need a variance, because it needs to encroach into the front yard setbacks. And we have at the last meeting there were a number of other kinds of solutions put forward, and I was at least hoping that the applicant could come back and say, well, we couldn't do this because of this or this or this, but we're not getting that kind of feedback. We still have to make the findings. So one of my questions is can staff work with the applicant so that the findings can be modified so that the Planning Commission can at least act on these?
We will do so, and we will also tie it back to the reasonable accommodation.
I mean,
I'm asking this. The other thing that I find a little disconcerting is the applicant has kind of muddied the waters here because they're taking the position that the family is unwilling to participate in the assistance of the person that needs the accommodation, that it's always going to be one way. And, it's up to us to solve a problem which is essentially maybe something that is more in the responsibility of the family. And I kind of am put off by that and a little disappointed, actually. So I can't make the findings as they are now, but if staff is being willing to rewrite the findings, then perhaps we can come to some middle ground. But it still doesn't sit quite well with me.
I mean, I would just like to say that I could easily make a finding that says we definitely need one 12-foot wide bay in the garage. I think that would be simple for us to make. It would be very obvious. And what I'm thinking about is the situation where I have seen people's homes where they need to have their handicap parking spot out in front of the house, right? Because they can't get in the driveway, or there's no driveway or something, and they give you one, right? They give you room to put one car in that, and that's considered a reasonable accommodation, right? So that you have a place that is accessible to whatever car that person is going to use, which could be their car, could be someone driving them, it could be a taxi, it could be anything that would be accessible to that person. And I think that would be a reasonable accommodation. Yes. Wouldn't it be? And so that's exactly the accommodation we're offering here, which is that you have a place that you can get in and out of, that you have a place to put a car. And to me, that seems like a perfectly reasonable way that would solve the problem of the encroachment into the front yard setback, and would provide a place for a car that would be accessible to the person who needs to get in and out of a wider spot. That we could make that finding, and we wouldn't have this issue with it could be 4 feet smaller and there'd be a 2-car garage. I could easily approve that right now. with a little bit more detail about the design and stuff, which we would also need.
Yeah, I need to,
but
I
think-
really need to interject something on that, and it's not an issue that staff rewrites the findings. It's that staff works and gets the right information and rewrites the findings based on that, okay? We've gotten enough rewriting of stuff here, okay? But the goods aren't here, all right? So staff is really gonna have to do some work on this design and then reflect it in the writing in the presentation next time, if there's a next time.
And, you know, for me, that there's some things that's kind of are obscuring or meddling in this process. You know, the applicant came up with a petition, and all these people signed the petition, but I'm not sure all the people that signed the petition understood the zoning codes of the city of Sierra Madre. They looked at a picture and said, would you like that? Okay, that's fine. But they didn't, I'm not sure they understood that, well, if you do this, and this is what, you know, our problem in this commission is that the things that we approve are going to be there for 75, 100 years. And we have to understand where in the city codes that this thing fits. And while we're happy to make the accommodation, we also have to live, the whole city has to live with the results. And then you can say, well, it's on this little private lane, no one ever sees it, it's not a big deal, but it's there and it sets a precedent and it's going to be there forever. And so we, at some point, have to have a reason, and so the reasonable findings are in place. And if the reasonable findings then can explain the position, then maybe we can swallow hard and move forward. Otherwise, we're in conflict with our own rules. We can make a reasonable accommodation. We can put a garage there. The garage can have a large opening to accommodate the driver. No problem. I don't think anyone on this commission would be, you know, deny that. I'm sure that vote would go forward. You know, but the problem is now the findings that we have. So I'll ask the applicant, if you want us to vote, we'll vote. But if you want us to continue and have you work with staff to come up with the findings that we can all live with, then we'll continue this so that you can work with staff. What's your choice?
No, I think we're happy to work with staff. We're happy to provide whatever information the council feels it needs to understand the questions that are pending. And I'm sorry that I'm not able to answer your questions today, but maybe working through staff we can get there.
To make sure that we're all on the same sheet of music here, do you understand our concerns?
So I understand a couple of concerns, and maybe it's a good idea to do a little review here. So one concern is, do we have the findings necessary for 2 doors at the 12-foot dimensions and the interior volume and space that you need to operate within that space?
Correct.
So we have provided backup for that, so we'll work with staff to clarify and make sure that that is in the format and provides the level of detail that the commission needs. And it wasn't our desire or intent to provide you less than that. We submitted it in advance because we weren't sure ourselves what was necessary, so we'll work to refine that. I am a little unclear on the drawing quality. We're happy to provide whatever you guys need. The people who did the drawing work for us, or they work for architects all over the San Gabriel Valley and Glendale.
We have 2 architects here. I'll let you guys chime in.
Yeah, we'll talk to you about it.
Do you want material boards or specifications?
Well, first of all, this isn't really even a professional CAD program here. You know, this is an illustration. This is an illustration program. There's so much deviation that could go on just in terms of how you want to interpret the picture by the time the thing is done. Normally, what we would be looking at would be a design development or a much later preliminary design thing, but it would obligate itself to a lot of critical dimensions and material callouts and so forth. And those material callouts would relate to boards that we would get to see. You know, I had some questions last time where the eave heights, you know, in the house and the garage, from one view here to another didn't really jive, and so, as I said before, it's kind of like, if you want to make a case to go out into the front yard setback, then you know, let's really have a design that is tuned here, and to me, design is all about these proportions, the scale of things. It's real easy, and I'm not criticizing the population generally, and I'm sure that a lot of the people who signed your petition probably feel seriously, as I do, that we should be able to accommodate this kind of situation. But you know, they're not here to listen to everything that we're legally obligated to respond to. And if you just show somebody a picture of something Tudor and say, well, do you like it? And that would solve our problem. And 9 people out of 10 are probably going to say, oh yes, just based on the fact that they like what they see in the picture. That is like way, way short of what we have to do as a planning commission here. And I think that you alluded to that before, Bob, as well. So Vincent, you know what we're talking about in terms of really professional drawings that are going to be like really right on about what we're getting in that front yard.
Does that help? Does that help?
Some more.
Yeah, no, and since Vincent knows the answer, apparently, we'll work with Vincent to make sure we get that.
Okay.
I just want to jump in here real quick. I want to make sure, I mean, the drawings are one thing, you know, but I think ahead of that, you know, I want to get justification or reason why the reasonable accommodation to meet that it's, you need 2 12-foot bays. If you can outline that for me, because ultimately, if this comes back the same way with just tighter dimensions or something and just says, well, we need to have this because of X, Y, and Z, personally, I'm in the same boat. So
It seems to me that.
and if we're doing the finding thing where we're just revising the findings to say, we can't meet any of these, but for the reasonable accommodation, then that's basically saying like, this project doesn't meet this, but because of this extenuating circumstance or reason, we can sign off on it. And that's fine, but I want to be clear, like, we're not going to make them come back and work with staff and do all this to basically get this same thing, you know, and then rubber stamp that.
Yeah, I don't want any
To me,
wordsmithing here on this at all.
why do they need better drawings and all of that if ultimately we're looking at this box here in the front yard and it's encroaching?
Manish, it seems to me what I'm hearing from you is that if there's not a need for 2 bays, 2 extra wide bays, there's a way you can design this garage that doesn't encroach in the
It meets
in the
everyone's
setback.
requirement, yes.
And so there really needs to be.
Like,
for
what
you-
does the
for you
code, does
to-
the
for
code
you
say
to
that?
approve
Does
it,
the ADA code say
It really
that?
needs to be a justification for 2 wide bays.
Yes.
As opposed to 1.
And I don't want just reasoning like, well, this code says that and the you know, federal ADA standard says that. If it does, I want to see that. If it does, I want to see it.
I don't think we're going to be able to make findings like that. Findings can, the request for the reasonable accommodation will certainly be folded in to the various findings that you would otherwise have to make. But I think the applicant needs to understand, as does staff, whether there are at least 4 votes to approve this project as it's presently designed, even if the findings are improved, or whether you believe that there are other ways that are reasonable to accommodate the need that's been expressed. And we don't really, I think, want to bring the applicant back for another meeting if that hasn't been resolved here. And so I think that they're hearing, yes, they're saying we'd like to work with staff, we want to give you what you want, but I do think there's a divide in understanding as to whether what you want is a different design, or is it the same design done by an architect who maybe could get the dimensions to fit, or is it a different design with one wide bay and.
Can I ask you a question? Do you believe that we would be following the laws about reasonable accommodation if we offered one 12-foot bay and one 8-foot?
Well, yes, but that's not my decision to make. Yes,
yeah.
I believe that it would.
Do you believe that would be legal?
That would be legal. That is not what the applicant has requested, but.
Why would that be legal? Because we are not required to do exactly what they
That's correct. The only way that you would be forced to approve 2 12-foot wide bays is if that was the only configuration, or to put it another way, if the only way that they could get a garage sufficient to accommodate the driving limitations of the person who needs it is a structure that encroaches into the setback, then you would approve that. Mm-hmm. However, this commission has suggested many possible solutions that are reasonable. And one commissioner, it can approve it as it is, with the observation that the prevailing setback on this street maybe could have been a different number from his perspective. So and this is all good information in the record, but ultimately, I'm not a big fan of straw votes, but are there 4 votes tonight? Do you know if there are a majority that will support the application, the design as is, if the findings are
modified?
Yes,
I
modified.
will not. I will
okay.
not.
I think we need to know that.
No, I will not. I
will.
don't want any words, bring the same thing back with the staff writing wordsmith some. No, I'll just deny. I'll vote to deny.
I'll do it.
Okay, so we have 2. Are there 2 more?
I think that some of the information we're asking for would make that decision. So I can't answer without seeing what they come back with.
Okay, but if they come back with exactly the same design, and the only thing that's new is material boards and better findings from staff, but you're looking at the same, that's what you have to think. And you may not be ready to say it tonight, but if we have them come back in 2 weeks, you will need to be ready to say it that night, and it would be helpful for them to know if there's support for the project as it stands, or if there just is not.
If they are able to show some way that the only possible way for this to be located there is within that encroachment, then I could vote for the project.
Okay, the only way, that they, okay.
That was
yeah.
That was one of the things that was offered as something they could bring back.
But I think city attorney is saying that they won't be able to make that as a finding.
Legally, we're not going to be able to make the finding that this design is the only way to accommodate. We will not be able to state that.
A reasonable way.
There are more than one way. So the question is, given that there are other options, can you support this one? If we make the findings, we fix the findings, they need to be fixed so that we're not, so that we don't appear to be violating our own code and granting someone an approval of something that people will point to later and say, but you made all these findings.
So here's my issue on that. I think that when we're making decisions about things like variances, which this essentially is.
It is, but we're
in
not going to
some-
make them
we're
do
not
that
gonna
now.
make it- Yes, we're not going to make them do it. But what we always want to do is to say, what my point of view is to encroach as little as you can beyond what the rules are.
Tread lightly.
To tread as lightly as you possibly can. So that one possibility to provide, the one you recommend, encroaches into the front yard setback. It seems to me there's another way that could provide a reasonable accommodation that, according to our attorney, would be legal, which would not encroach into the front yard setback. Well, it seems obvious to me that the choice we should be making is the one that has the least impact, going over what our zoning codes are in the city of Sierra Madre. So that, for that reason, I would say no. I think there's another way that it could be done that does not encroach, and that's what we should do, rather than have to encroach in this.
So would some of the possible direction to the applicant be to see if they can work with an architect to see if there is a way that a structure of the size that they're looking for can be placed in the front yard with less of
That's
a
why I brought it up
setback?
last time.
Yeah.
Yeah.
I believe that there are solutions to this problem. I don't believe that we have to be locked in this position. The problem is that we've only been given one choice, and we've spent a great deal of time and energy on discussing this building. I mean, more so than there are a lot larger projects that came through in a lot less time. I mean, including, Kensington. So, we believe that there's a solution for this, and we are not here to deny reasonable accommodation, but what we still have to have, we are still bound by the rules of the city. And so, the reason I talked about an architect is that, they're very clever people. They can make space, they can use space in creative ways. You and an architect, or you and somebody can, and we don't need to know it, but they can understand your needs and design for that. I mean, how that looks and when it comes back to us, I think we've tried to explain to you all of our concerns. You've been listening very carefully and taking notes for now 2 meetings. And we're not a really obscure group here. We don't, we get into the details, but we try to be very transparent. I mean, I as the chair, I really want to be transparent. I want the citizens, because we're on television, I want the citizens to understand our decision-making process. So it's not as if we are, trying to come up with goofy things. We need to understand, we ask questions because we need to understand them. And I think we've asked enough questions so that you can come back and provide some answers without breach of confidentialities. So, I would hope that we could continue this, and you could work with staff, and we could come up with some solution. Okay?
Okay.
Thank you very much. I appreciate it.
If we're going to do that, I would like to give staff and the applicant some more direction with regard to the findings, not necessarily the project. That's here to there for this. So with regard to finding number, we're talking about the design review permit, finding 3, there's an issue of siting, and I think we need to call out the issue of siting of the garage in the front because to accommodate. And then in findings 3 and 4, there's an issue of bulk, scale, mass, and scale of the neighborhood. And there we have a bigger project than normally would allow for 2 reasons. One is because of the oversized bays of the garage. And the second is we effectively have 2 garages because we're converting the old garage in the back into storage and we're building a new garage. So I think those things both need to be called out. And then even more troublesome to me is finding 8. and I think there's a number of sub-findings that we need to work on. 8A, we talk about innovative and thoughtful architecture, and that we need to talk about the innovativeness and the thoughtfulness of it is how we're accommodating the disability. I mean, that's the whole reason the thing is in the front, right? And so I think it's appropriate to say it's otherwise thoughtful.
So here's the solution. If you go down to the beach and they have garages that are right on Pacific Coast Highway, each one of those garages has a round table in it. You pull in, it turns the car around and goes out. You never have to back up. But that's things that architects do. They know about these things and how to do them.
That's an expensive one.
Okay. Solves the problem.
Can be manual.
Okay, move on. B is really not applicable. I think C really, in the context that we already have a house, C isn't really that much applicable. So, because we already pretty much have a pad for this. D really talks about siting of structures in here. This is a big issue where the siting really is because of accommodation rather than the standard methodology of putting the garage in the back. E goes into high quality architectural details, which it would be good to have more information on those. And I think the fact that it matches the Tudor style is sort of a no-brainer, and I'm glad that's in there because it wouldn't make sense to have it some weird thing that doesn't match. And then on F, with regard to sustainability, we need to delete the reference to the rain barrels, and we need to either have more detail on how we're going to accommodate, or it seems to me we need to be at least more straightforward in the conditions of approval that we're going to apply the LID and the water efficient landscape standards. And we should probably even just call those out in the finding as one of the reasons how we're going to save water.
So there's a finding in here, and I can't remember which one it is now. I'm scanning through it, I'm not seeing it, that says because it's a private street, views don't count, and I just don't agree with that. Because even though it is a private road, people have access to it and can go walk up and down there and stuff, and I just think that is not an appropriate thing to include in the finding.
Private street means that pedestrians are precluded from it too.
Right.
Well, I think that's finding 5. I agree the reference to private road isn't helpful because the other thing is the finding itself talks about public and private views and privacy from neighbors. So I don't think we need to have a reference to private road at all in there.
Yeah, I just don't think that fits with the finding.
You know, John, there's something else that's buried in here when you're reviewing the I agree with what you've had to say. It may be helpful to staff, but in addition, if we go down to the reasonable accommodation request findings, they all seem to be saying that it's for behalf of a person with a disability that's protected by law and so forth, that the requested accommodation isn't going to do this to the neighborhood or it isn't going to do that to the property. But you go through all the findings and it doesn't say anything in there about what findings have to be made for the reasonableness of the request at all. That's just kind of been talked about here, but there isn't we've been doing it, but there isn't really a specific finding that.
I think I would let staff consult with the city attorney to make sure whether any of that gets written down.
Sure, I'm not an attorney, so I agree. I would leave it to them.
So our staff is okay with moving forward on this and can assist the applicant, and the applicant will work with staff and
Yes.
and then hopefully in a short period of time we can all be.
Okay. So we are going to be able to give both staff as well as the applicant time if we could continue the project to a date
Uncertain.
or
So
uncertain.
we're looking for a vote to continue for a date uncertain?
And if that's the case, then we will have to renotice the project.
Okay.
Well, do we want to do that, or do
Or
we
do you
want to
want
make
a
a
date certain?
sort of guesstimate about when we could actually get the stuff done that we want? And
Yeah.
So we would be looking at a meeting possibly in August 3rd, August 17th. Actually,
Not third.
probably, depending, if they have to consult with an architect, they're gonna have to try to find one, accommodate their time frame as well.
Would you be in a position to suggest or refer?
Staff
Some-
doesn't make referrals.
Can't
but
do that.
architects.
Can't do that,
Yeah.
okay.
We have 3 in the area we've worked with already.
Okay.
yeah, I think we should, I don't know if you think you can do August 2nd, if not August 16th.
Do you have a preference?
Yeah, I'd like to keep this moving too.
August 16th sounds like
I
best
think
for staff.
August
Which is
16th.
the next one after that August 17th date?
The September date.
Oh,
September
September
6th.
6th, yeah.
That would, I think September 6th would be preferable if we can do
Okay.
that.
Is that okay with staff?
Yes.
Okay, let's do that.
Does that need a motion, Bob?
So it needs a motion to continue to date certain?
To continue to the meeting of September 6th, so moved.
No, August.
Oh,
Moved.
November,
September
September
6th.
6th.
So
September,
it's
yeah.
been moved and
Second.
seconded. All in favor?
Aye.
Anyone opposed? Great. Thank you very much.
Okay.
So at this time, because it's 9 o'clock, we'll take a 5-minute break and then come back and deal with the second one.
live or not.
Okay, we're returning from break. At this time, Commissioner Catalano had to leave, so we still have a quorum. So we'll proceed with the second item on the agenda.
The second item is a public hearing regarding the commercial code amendments that the commission has been working on for quite some time. I do have a PowerPoint presentation for you this evening, so I'm going to launch that at this point.
Oh yeah, we can sit over there.
So what I wanted to do this evening is actually, we wanted to confirm and get concurrence from the commission regarding some of the modifications that we had at the May 17th meeting. So that's where we are going to begin. And I have shown excerpts of those specific issues in the staff report, and they are reflected here in the PowerPoint. One of the reasons why I'm doing this is it is a public hearing, and we do have the viewing public also looking at some of the decisions that the commission has made and the recommendation that's going to go before City Council. So the final edits that were made by the commission at their last meeting include changes to Chapter 17.08, which is part of the definition section, and also Chapter 17.36, which is the commercial zone. And the commission also had one final edit regarding the director's list of commercial uses. So the changes are represented in the following slides. Simple enough, Chapter 17.08 definitions includes modifications or deletion of the definitions that are represented here as underlined or as a strikeout, red line strikeout, eliminating fence and non-conforming building structure or use and wall definitions from the overall chapter.
And that middle one was just a weird heading that was,
yes.
Remember, yeah.
Mm-hmm. Moving on, the next change that was made was to Chapter 17.36.020, Section .020, which had to deal with permitted uses and uses permitted by conditional use permit. The commission at that time asked that, for clarity, that the staff include in each of the headers, in each of the subcategories, whether it's permitted, requires a minor conditional use permit, or whether it requires a conditional use permit. So that has been introduced in each of the use categories in the revisions. The next one is also still in the commercial code, but it is Section 17.36.040 design criteria. There were a couple of items that were corrected, as we can see in the underlined strikeout, and also in the inclusion of a graphic that details the articulation of a second story. And the final issue that was remaining was modification to the director's use list, specific to the retail sales category, use category, and specific to heightened review, which requires a conditional use permit. And it's a modification to a definition of tobacco, where we introduced e-cigarette sales into the overall definition. So if there were no further edits to each of those, we can move on to looking at the overall changes to all the codes. So the commission will be taking action on Municipal Code Text Amendment 18-01, and the commission will be considering forwarding a recommendation to the City Council to consider amending the commercial zone Chapter 17.36, as well as the other related zoning provisions that some of them that we just looked at, such as the manufacturing zone and the discretionary review and variances and discretionary review. So we'll go through each of those as we move through the presentation. Generally, what I'd like to begin with is the General Plan Implementation Program. That was adopted as part of the 2015 General Plan Update, and it requires that the Commercial Code be amended pursuant to Implementation Measure 5, which I've included here, which includes direction to enforce the commercial zoning ordinance and amend it as necessary to maintain an area of the city for commercial uses, to also update standards for new construction, and to include those uses that wishes to encourage in the downtown area as permitted or conditionally permitted uses. I recall early on in the conversation with the Commissioner had also highlighted numerous general plan policies, objectives that I believe took up probably about 8 pages from the last I saw. So in lieu of including all of that again, we know that they're there. I might include some once I go to the City Council, maybe as an attachment as well. But this gets to the primary focus of the matter at hand. So the last major revision to the commercial zone was adopted back in July 2009. So it has been some time since the Commission has taken an overall comprehensive look at this chapter. And staff and the Commission have noted several flaws with the current ordinance specific to the reuse of existing structures, restrictions on business uses, and parking within the downtown. And the Commission also had conversation about parking. I know we had one discussion prior, and as part of this overall update, we decided that we needed to take that on specifically and kind of separate it from this issue. We did address a couple of minor modifications to parking standards, but we'll come back later on with a more comprehensive look and hopefully make a decision that we could pair up with the changes that we're making here. So the objective of the Municipal Code text amendment is to update the list of permitted and conditionally permitted uses in the commercial zone, update the corresponding development standards, and develop a comprehensive list of commercial uses to be maintained and updated by the director. The Commission also formed a 3-member subcommittee that was tasked to provide recommendations for a complete overhaul of the commercial zone. The committee also recommended amendments to related zoning code provisions in an effort to achieve consistency specific to cross-references in the commercial zone. As I mentioned before, we addressed the chapter of 17.08 definitions, 17.40 manufacturing zone, 17.60 variances and discretionary permits. And the Planning Commission again also developed a list of commercial uses. So the amendments to chapter 17.08 was basically a general cleanup of that chapter, and there were a number of definitions that were deleted, and also a number of new definitions that were included, and quite comprehensive. Didn't want to list them all here. It is included in the packet for a detailed review. The amendments to Chapter 17.36 Commercial Zone, as I stated earlier, it was replaced in its entirety. First, the regulation of use was separated from the design, and this allows review efforts for new development to focus on design criteria rather than use.
Will you use the same PowerPoint for the?
Yes.
So you might want to take form.
Yes, we talked about that. So use categories, basically one of the second issues that the Commission decided to do was to revise how the uses are regulated. So the Commission came up with use categories. These are the specific use categories that appear in that code. And I'm going to just use retail sales as the example of how this is all broken down and detailed. So as the use category of retail sales, it's further refined by levels of review based on square footage, as you can see, as well as whether it's a permitted or permitted with a minor conditional use permit or a conditional use permit. And it goes through the different thresholds. So in the actual code, all we will see is retail sales general, retail sales limited review, and retail sales heightened review. And it's based on the threshold of size of the project. The next section of the, actually it's separate from the code, well, it's included within the code under those, the retail sales usage. It will list a series of different classifications. In this case, this is the retail sales general. I just picked out a couple from that long list. So in this case, it's art supply stores or pet supply stores and supermarkets. And it's again, it's based on the threshold or size of the project, and that identifies the type of review that's required. So this is retail sales general. Then there's a more detailed classification called retail sales limited review. And this section only has two permitted types of uses. One is a minor conditional use permit, the other is a conditional use permit. Again, the thresholds is less than 5,000 square feet or greater than 5,000 square feet. And these are actually the three provisions within the limited review. It's glass repair shops, home improvement and construction product store, and pet sales. That's what appears in the code in its entirety that we see under this classification. The next is retail sales heightened review, which requires a conditional use permit automatically. And that would be for alcoholic beverage sales, whether for consumption on or off site, whether alone or in conjunction with other uses. Gun and firearm sales, whether alone or in conjunction with other uses. And tobacco and e-cigarette sales, whether for consumption or on site, and whether alone or in conjunction with other uses as well. And we have a footnote here that states that this includes any product intended to be smoked or vaped other than marijuana. We have a whole separate section that addresses how we address cannabis laws. The amendments to Chapter 17.40, manufacturing. Because the commercial zone uses are allowed in the manufacturing zone, we wanted to review what those impacts might be specific to the East Montecito Avenue district, or the specific, or it's not a specific plan, the zoning district there. So changes were made to accommodate the manufacturing code only as necessary to make the cross-referencing work for some minor cleanup on uses. And John is, and many of these arguments are coming from the initial memo that John had prepared in our initial conversations at the very beginning. The amendments to Chapter 17.60, variances and discretionary permits. So under current code, municipal code, the municipal or the minor conditional use permits currently apply only to residential uses, and the proposed code revisions expanded the use of a minor conditional use permit for commercial uses. And similarly, the findings for a minor CUP were updated similar to the CUP findings, so we have some consistency. And the list of generic use categories were updated in section 17.60.030, which is conditional use permits when required. Also updates in section 17.60.055, which are minor conditional use permits. And a cross-reference was added to section 17.60.041.d.8, design review permit for oversized projects, which requires a conditional use permit. So the alternatives before the Planning Commission this evening is to recommend approval of Municipal Code Text Amendment 18-01 to the City Council pursuant to Resolution 18-06. Recommend approval with modifications, recommend denial, or continue the matter and provide direction to staff. The recommendation is, staff recommendation is alternative number 1, that the Planning Commission recommend to the City Council adoption of proposed Municipal Code Text Amendment 18-01, amending Chapters 17.08 definitions, 17.36 commercial zone, 17.40 manufacturing zone, 17.60 variances and discretionary permits, and the list of commercial zone uses to be updated by the Director pursuant to Planning Commission Resolution 18.06. So that concludes my presentation, and if we wanted to address any questions at this point, or take consideration for a motion.
Questions for staff?
Yes.
Well, I move.
Before we move, I just wanted to say,
I second.
also, yeah, of course. No, I want to say good things about Manish because the incorporated also are the revised and updated diagrams, which I think are really helpful
Yes.
in understanding. And the one about the side articulation, we had issues on how to display, because if you show a whole building, then you might have FAR issues or whatever, and that's why there was that like jaggedy bit to say, look, we're just talking about this line here.
I do want to publicly acknowledge John Hutt's contribution on this. Without him, this project would still be slogging through the mud, and and it's he has played a key role in this, and I for one am very grateful to it. Thank you.
Likewise, yes.
Well, thank you very much for the kind words. I do think though, we got to understand it's a team effort. A lot of work put in by the subcommittee, the whole commission, the staff. Even though we obviously bored the city residents to death on this, but we did get a lot of community input, both in our meetings and in subcommittee outreach, and also a lot of these topics were discussed in the past in town hall meetings for the updating the general plan, and even back as far as the dreaded downtown specific plan and Measure V issues. And it's important to note that all of these revisions are Measure V compliant, and I think that it really goes a long way to helping energize and facilitate the reuse of buildings so we can get more storefronts filled up, but still and enhances our ability to regulate big developments, which is really the fear that a lot of people have, without stepping on new businesses or somebody trying to put a little storage shed in the back or something like that.
And the city is interested in promoting more commercial activity, and hopefully this will allow that to happen, which is what our goal is, to do it in a regulated way. Anything else? I'll be ecstatic to entertain a motion.
John has to make the motion.
I would be very happy to move approval of Planning Commission Resolution 1806, recommending adoption of the various code amendment changes to the City Council.
And I would like to second that motion.
It's been regularly made, moved, and seconded. All those in favor?
Aye.
Anyone opposed? And it passes. Thank you very much. Major accomplishment.
Yeah.
So, subcommittee members, John, Bob, Gina, and then you contributed with illustrations, right? Yeah. Okay.
Do we know when this might go to council, or is that?
I have that scheduled for the second meeting in September. I believe that's the 24th.
Okay.
Yeah. We should, as many of us as can, go along.
And since we now have a regular meeting with a councilman, we should put this on the agenda for them, for them to preheat them to our logic and our thinking so that we can have one person at least understand how we ended up with the decisions.
Yes.
Okay. And they may be able to inform us as to things that we should emphasize when we make a presentation.
Okay.
So you said that was September 24th?
I believe it's the 24th.
It's a Tuesday?
Yep.
That's the 25th.
25th.
25th? You got it, okay.
Yes.
Okay. Next up is an opportunity for oral communication from the audience, but they obviously have so much faith in our ability that they don't need to be here, so we will go.
One way to look at it.
We'll look to the planning commissioners. Any items for discussion from the members of the commission?
No.
Everybody's good?
We've discussed enough today.
Okay, we did, yeah. And now we look for staff report. Anything?
We do have an item coming up for our next planning commission meeting. Second meeting in July. I believe that's the 24th. So it is a new house. It also includes the rehabilitation for a second unit and accessory structure. It's the Wayland property. He's a local artist in town. And per the Historic Resources report, it came back that the studio was culturally significant.
Oh.
So we'll be evaluating that project.
Excellent. Okay.
And that concludes my comments.
Okay.
That's July 19th.
No.
Let's see, I actually have the agenda, the calendar here. It is July 19th, yes.
Okay. Excellent. All right.
Not the 24th.
With that, we stand adjourned.